Recording. Just off this for a moment. This is already recorded. Okay. All right, and then test. Sounds like people can hear me based on how my icon is giving off little circles around my head. If I cannot be heard, somebody please send a message in the chat. But in the absence of that, I will proceed. So this is the webinar for my law office, Chaudhary Law Office. My name is Max Chaudhary. I am a Canadian immigration lawyer and have been in the practice of Canadian immigration law since at least 1995. So about 30 years. And the purpose of this webinar is to allow people to have some general guidance about their Canadian immigration, Canadian visa, citizenship, refugee, etc. matters. As I've indicated in the chat, please pose the question or questions or follow-up questions in the chat, because that might be a little bit easier for me to digest, and as well because excerpts of this will be on social media. Please, when you're posing a question, try to maintain confidentiality, just because, it's confidentiality is highly prized in this day and age. So with that in mind, I think I just like to give a bit of background about the kind of nature of immigration dissemination of information, which is basically we are at the mercy of the Canadian Immigration Department, which in turn is accountable to the Canadian government, which ostensibly is supposed to reflect the will of the Canadian population and the best interests of the Canadian population. Well, that being said, immigration matters sometimes are subject to political factors. The phrase political football comes to mind, which means that sometimes there are abrupt changes to policies, and these could take the form of what are called ministerial instructions, which is simply the minister not passing a law, but saying, I have these particular instructions based on what I feel is in the best interest of the Canadian, for example, Canadian economy, or the goal of family reunification, as the case may be. And because of that, that makes Canadian immigration law somewhat more difficult to navigate, because these ministerial instructions tend to come with very little fanfare and become unannounced. And they have a broad impact and a comprehensive impact on people who are applying under a specific policy, which may be affected by these ministerial instructions. So with that kind of in mind, I want to give some guidance in light of these things. And by all means, please pose any questions in the chat. The people tend to come at various times during this webinar, and people come and go, in fact, particularly after they have received an answer to their question. Hopefully it was a useful answer, and that's the reason that they're leaving. So with that in mind, I take a look at the chat. So one is basically relates to, I think, what I touched upon, which is sort of the political intermeshing with Canadian immigration policy, namely, has the rhetoric from Washington had any effect on the Canadian immigration climate? So with the 47th president of the United States, there is the most amplified impact of this is when we see, quite frankly, for the most part, educated Americans, well-off Americans, and professional working age Americans who have been making queries even after the election in November, and touching into as recent as maybe a week ago, we get persistent queries from people in America, such as American citizens, and people in America without a clear status, maybe a work permit status such as H-1B, or study permit status, or asylum seeker in the United States, making queries about what is available to them. I've had a particularly unfortunate situation that I came across last week, where somebody from the United States with no status wanted to make a refugee claim at the Canada-US border. And under what's called the Safe Third Country Agreement, you can make a claim in Canada if you landed first in the United States, as long as you have a Canadian relative. And the Canada Border Service Agency had said, well, we'll give you 24 hours to produce evidence of your Canadian relative. Otherwise, we will not let you commence this application for asylum in Canada. Well, the problem was this person had encountered, I suppose, by traveling, had severe frostbite, and he had to get emergency surgery to deal with his deteriorating digits on his hands. And that was emergency surgery, so the deadline was missed. And then The Canada Border Service Agency consequently did not receive that evidence. And as a consequence, he lost some of his digits and he was issued what's called an exclusion order, which prevented him from making a refugee claim at the Canada-US border. So that's the most vivid example I've seen about the sort of implications of the kind of flurry of political action in the States coming in the form of executive orders and being responded to with what looks like, I believe, court challenges from the judiciary in the United States. And so that means that kind of sort of flux in what's happening in the United States is having a definite impact on people at least making queries and making efforts to try to avail themselves of some form of Canadian protection, which means that one might question whether the United States is a safe haven, for example, certainly for refugee or asylum claimants, and perhaps increasingly, as one person indicated to me who has a transgendered relative, whether it's safe for certain LGBTQ plus, etc. persons based on the climate that is emerging, which is being buttressed by US government policy. So in short, yeah, there's a huge impact. And on the other hand, it's also causing some kind of people to kind of wait things out and see what might transpire with the Canadian authorities, with the hope that, well, with a new Canadian Prime Minister and a new immigration minister announced last week, relevance for people who are in Canada who want to regularize their status because the pathways for permanent residency have been truncated to, in light of the significantly high amount of immigrants that we've received in 2024. The projected numbers are going to be reduced for the next 2 years. So again, that's sort of the positives and negatives in terms of impacts on the Canadian immigration system as affected by political changes, both in Canada and the United States. So with that in mind, I'll take a pose or a stab at any questions I see here in the chat. And so it looks like a very specific question. So can a post-graduation work permit holder take a short course for 5 months without a study permit? Or would a study permit be required? So generally speaking, if the duration of the course is less than 6 months, then you don't need a study permit for that, because I suppose that comes under the ambit of maybe lower level vocational training. And for whatever reason, we don't think that you're depriving Canadian students of a potential opportunity to take these 6-month courses, maybe because they don't take these 6-month courses as often. So that's sort of the policy rationale. And also, I think it's more administratively simpler for the Canadian Immigration Department to not have to issue a study permit for something which is of a shorter duration. So, I mean, the short answer is yes, you can use your existing post-graduation work permit and take a course of study of less than 5 months duration in Canada. And if I see the follow-up, there's a reference to the regulations. It mentions, I believe, Regulation 188, subsection 1, subsection C. A student can study in Canada without a study permit if the course is less than 6 months. Okay, so it mentions student, and then there's a question related to that statute, which is, does the term authorized stay upon entry in section 188, subsection 1, subsection 3, refer only to the duration? Oh, looks like the question got away from me. Only to the duration of the initial study permit, or does it extend to the entire stay, including the post-graduation work permit period? So I would want to look at the statute in more detail. Maybe if you have a chance, paste in the other related sections that I can sort of reflect upon that, because if I'm going to say the law permits a certain thing, I want to have certainty about that. So we have note takers and things of that nature. Okay, so in the meantime, we still have a great deal of time. And okay, so we have a follow-up related to what I just posed, right? So if we look at this particular regulation, let me see here, right? Let me just see if I can look up my soup one second. Sort of multitasking from time to time, right? So let me see here. So regulation 188. Okay. I'm hoping this will reveal something that I could learn from, because that's always useful, right? If it doesn't, then I'll probably just default to what I just said about the ability to study. But let me see if there's anything corroborating or addressing any kind of concern based on the question that's being posed about the ability to study. So if we see this section, just bear with me, please, here, and then, okay, so when I read the section as a whole, it looks like you don't need a study permit, but you can still apply for one. And then I think the question might have related to timing, which in turn may relate to the ability to possess status. The question you might have, it may intersect with another section of the Act, and I can't recall the section. But the bottom line is, as I indicated initially, that a course of 6 months or less duration can be secured and completed despite the fact that you may only have, for example, visitor status, or maybe only a work permit status. So if there's something more specific out of that, there may be another section you could refer to me with rejiggering the question, for example, and then maybe I might have something more to add to that. We have some, okay, I see a hand raised. So maybe, as long as you don't mind your voice possibly being on social media, you can say something, right? I think it's somebody, I'll just let them say. I don't want to utter anything personal at all during the course of what I say here. So if there's a hand raised, somebody could speak if need be.
Sorry, if I may.
Sure.
Thank you so much. So I attended your last webinar also. It was very insightful. So the biggest confusion is, as you rightly mentioned, that there is no study permit required, like less than 6 months. So 181(1)(c), at the end, it says...
Okay, 188(1)(c), right? All right, so then if we look at the particular focus of that subsection, then it's, in a sense, it's reiterating in a more certain way that the person has to have valid status throughout the duration of the 6-month course of study.
Can you hear me, sir?
Sorry. I can hear you, yes. I think maybe you might have said something that I missed, though. So if I did, please repeat. Yeah.
So sorry. So I was saying, So upon entry is, there are two school of thoughts. One is saying upon entry is when you initially enter as a student and like say 2-year study permit was granted. So you have to do that within 2 years. Others is saying upon entry doesn't mean anything. It is the authorized stay, because study permit was after that authorization stay was extended with the postgraduate work permit. So that's why the biggest confusion with these two school of thoughts upon entry, that's the big confusion. So love to know your thoughts and insight on it.
So when we interpret these statutes, we try to think of what is the policy rationale and what avoids any kind of perverse result, and at the same time policy implications for a regulation or a statute leads to the question of what is realistic and what is maintaining the integrity of the immigration system as a whole. So I would opt, based on those factors, those sort of policy-based factors, to interpret that the course has to be 6 months or less, and would have to be done within the duration of the status that has been conferred on the person, which is very, very, I think, sort of what we call the plain and ordinary meaning. I'm curious about the other interpretation, which may have the effect of being too restrictive on these things, possibly. But I mean, if you have a different interpretation, yeah, you can flesh out the initial one. I can reflect on that and see if that comports with the basis for how we interpret statutes, which is the stuff I mentioned earlier, policy and integrity of the system, etc. But at this juncture, when I read Regulation 188 as a whole, it seems more preoccupied with two things, namely the duration of studies being under 6 months or less, and the person having status during the entire 6-month period of time, which is, I guess, I would characterize as a plain and ordinary meaning for this. With that in mind, there are certain hybrid situations where, for example, if you came as a visitor or a worker and you only have 3 months on your work permit left and you commence a course, then certain things would have to be done to ensure that you don't get issued with an exclusion order, which is basically a 1-year deportation order. And that is basically ensuring that you have extended your status, and then if you extend your status by filing the appropriate extension as a visitor or as a worker, paying the appropriate fee and filing the appropriate forms before the expiration of the current status, then you would have what's called maintained status. And I would take the view that if it's a course of less than 6 months duration, then as long as you have extended your 3-month period for another 3 months or 6 months by simply filing the appropriate extension before the expiration of your 3-month status, then that maintained status would be a status that you could continue to finish the last 3 months of that hypothetical 6-month course. That's how I would interpret it. The other one, I'd be interested, maybe if you could type out something about the initial interpretation. So those are sort of my initial thoughts, taking an initial look at this, right? So in the other situations, right, this sort of ties into the phenomena that we're seeing now, which is people who are inside of Canada, oftentimes who had acquired a study permit of 2 years, and then prior to the recent changes, were very easily able to get a post-graduation work permit. And the expectation was that the system would allow them to acquire permanent residency under the express entry system, which has the subcategory of Canada experience class. So that would be a person who studied and graduated in Canada and would build on that by getting Canadian work experience. And logically speaking, the idea was that, well, this person had a Canadian credential and Canadian work experience. It's at a particular skill level. They've demonstrated that they've worked for 1 or 2 years, so why not give them permanent residency? But the situation now is, with the recent changes, is that they're only giving out work permits in certain occupations now. So that will lead to a lower quantity of people in what's called the express entry pool, which is essentially an inventory management system where we treat candidates for immigration as inventory in a pool. And the logic is that because there were so many people who were graduating and working in Canada, there were simply too many candidates under the Canadian express entry subcategory of Canada experience class. And now the points required for a successful invitation to apply have exceeded well over 500, which was not the norm before July 2022, where it was simply quite common to have the point threshold of 480 and even as low as 430, which meant it was a lot easier for people to immigrate after their Canadian studies and their Canadian work experience. So the plan now, if you're in this situation, is not a lot, right? My concern, I do feel the concern, and the government hears this, which is those persons who graduated a year or two ago before the changes took place, and they may not have tailored their course of study to something that is in demand. And that means that although they're able to place a profile under express entry, such as the subcategory CEC or Canada Experience Class, they will not likely get selected unless their work experience is under what's characterized as a targeted draw. Targeted draw these days tends to mean science, technology, engineering, mathematics. Oftentimes, it included IT jobs, but now with the most recent list, most of the IT jobs are gone, except for, I believe it is cybersecurity, because the internet is a cesspool of scams. And so there's a constant demand for ensuring that there's people who have the expertise to deal with that. But arguably, the policy changes even worldwide. I mean, for example, the letting in of 180,000 Ukrainians due to the now 3-year war in Canada, allowing them to work, no doubt has had an effect on people who were in information technology, because it tends to be that a significant amount of Ukrainians, or a significant minority of Ukrainians, do have a lot of skills in IT, and that arguably could have been part of the reason for the absence of most of the computer science jobs on the most recent list announced about 10 days ago by former Minister Miller. The new immigration minister, her name escapes me, but suffice it to say that a lot of the promises that were made by the old minister, I mean, these are very sort of oblique promises, but there was some at our stakeholder meeting with the immigration minister. The Canadian Bar Association did hear from the former minister that they did want to have some kind of enhancement or alteration of the economic immigration program to deal with those candidates who were no longer competitive owing to the fact that their studies completed perhaps 1 or 2 years ago, and that the requisite job that they have is not going to be subject to the targeted draws, and hence would have a much lower chance of success under the express entry immigration system. I'm hoping the new minister will work on that promise, but be that as it may, it was a little bit of editorializing and speculation. But with that, I'll go to the additional question, right, which is the stuff that is going on in social media, which we have a love-hate relationship with social media, immigration lawyers, because it's our tool to promote ourselves, but then we see a lot of rumors which are not borne out. So with that in mind, let's see. It says here, some posts suggest that IRCC is issuing procedural fairness letters, or PFLs, because applicants have listed work experience on LinkedIn that was not mentioned in their immigration applications. So it's kind of as a lawyer, as an immigration lawyer, or if you're a licensed immigration consultant, it's important to realize that the client, we don't want to infer bad faith on a client, but sometimes LinkedIn is used as an avenue to get a job, and they may embellish their experience for the purpose of getting a job. However, as is obvious, LinkedIn, for the most part, is a publicly facing platform. So the mechanisms available to the immigration or visa officer include the internet. So if you say you're the chief of super mega complicated surgery at a hospital, and then they see that you're supervisor of a shoe store on LinkedIn, under the law, it's reasonable for the officer to express doubts and, as a courtesy, issue you a procedural fairness letter, which is the equivalent of what they call in the States due process. We're saying, well, I have concerns that you say you're chief of super mega complicated surgery at this hospital, but at the same time, it says there's an overlapping period of employment which says you're a supervisor at a shoe store. I will give you 7 days or 30 days to respond. And in theory, there may be a viable explanation, but the responsibility of the officer is to give you that due process. I mean, if they only give you 7 days, which is what I've seen in the past couple of years, you can ask for an extension. And then hopefully you can marshal evidence to address the concern that the experience that you are relying on as the basis for your economic immigration is genuine. And that could be buttressed by somebody from the hospital saying, oh yeah, this guy does, or this lady does do complicated surgery at the hospital. And here are some pay stubs showing this person makes money commensurate with a surgeon or whatever, right? So the overall trend, though, is that officers, under the law, they're supposed to issue PFLs if there's a concern that you could not reasonably be aware of when you're submitting your application. In some cases, some officers are more difficult. The polite phrase for that is more difficult triers of fact, which is a fancy way of saying they're more skeptical. In some situations, an officer might not even issue a PFL saying, well, this is your profile, so why should I could refuse this? I mean, that could be challenged at federal court, because when an officer is using extrinsic evidence, namely evidence that was not forming the or within the four corners of what you filed for your Canadian permanent resident application, it's not within the ambit of that, it's extrinsic evidence, and then how could you reasonably be aware? The officer would be relying on this. This would be a sort of a borderline case because the LinkedIn profile is, in a sense, your own evidence, albeit not presented to the Canadian visa office. So it may take some specific kind of strategy to deal with that, depending on how severe the adverse information, for example, from LinkedIn might have on the perception of whether or not you did work in the occupation you claimed to work in. So those are sort of my thoughts about that. The other aspect, which I think is I'll touch upon since I don't have any questions, is that there does seem to be a trend for the officers to refuse. I suspect, I mean, I have no proof, but I suspect they're being told orally without any written instruction to try to refuse as many applications as possible. And also there's targets for each year, and then the targets reset. And perhaps maybe when the quota opens again for the next fiscal year, then they will be more amenable and less likely to issue blanket refusals, particularly for temporary resident applications like student or worker or visitor, because we do see quite a few of those now in the recent past. So with that up, there might be maybe a related follow-up to that, right? I was sort of touching upon the PFL comments that I've previously made. So there is this does, when I read the further comment, the heart of that comment is that when you file a permanent resident case as an economic worker in particular, there's various forms. One form talks about personal history, and the other form talks about work experience. So the sort of golden rule is that you have to have everything in your personal history. Otherwise, that could be a Section 40 misrepresentation. So in contrast, as the person has indicated in the chat, LinkedIn work experience does include work which may not be paid for, but looks good for the purpose of resume presentation for potential employers. And in that situation, if an officer encounters something saying, wait a second, you were doing this internship and it wasn't in your application. The more particular question is, was this in your personal history form? If it was, there's no misrepresentation because it's in your personal history form. And then the presumption is that that personal history form, along with the form dealing with work experience as a whole, would be internally consistent. So there would be no contradiction casting doubt on whether you did perform a particular set of work experience at a particular venue or not. That relates to, that's a very clear-cut case. On the other hand, if there is a situation where the person failed to put in, let's say, an internship on the personal history side of their application, and also did not include it in their work experience, then that could be a material misrepresentation. But the comment I think is relevant is where the writer says, considering that under subsection 40 of IRPA, misrepresentation must be material misrepresentation. Can it be justified that this does not constitute a material misrepresentation if no points are being claimed for it? There's been some success at the federal court about this. Materiality is a really amorphous concept. To get a handle on how it could be interpreted, you look at the type of application that you're dealing with. For example, broadly speaking, I mean, there's different types. There's like refugee/asylum, economic immigration, family class, things of that. Those sort of the broad categories. And then that could give a clue about what is material. In this particular type of situation, when this is an economic category-based immigration, then front and center of these types of applications is work experience, because that's how you qualify. You say, I have work experience doing whatever, right? That's at a suitable national occupational classification tier level. And in that situation, what has to happen is, if you're faced with a difficult situation where you did not declare this, then you have no choice but to argue lack of materiality for this. I found this kind of defense is actually good if what you omitted actually can strengthen your the perception that you are a person with genuine work experience. In other words, the internship was perhaps related to the work experience category you relied upon. And as such, there'd be absolutely no negative impact on the integrity of the immigration system, nor on the question of whether or not you would be able to economically establish yourself in Canada based on the occupation that you relied upon for your express entry profile, be it as Canada experience class or federal skilled worker or federal skilled trades. So the short answer is yes, there would be possibly a defense, depending on how related that omitted experience or internship or education was to the economic category that was the basis for the permanent residency. So I hope that was a bit more comprehensive. So with that in mind, though, then the idea would be, at this juncture, when we encounter people who attend these webinars, they've either filed something and they're waiting for the outcome, or they are considering filing something and they want to get a handle on what that would be like. And sometimes they ask about the potential application that they're considering and the criteria, and they might disclose a bit of background. Sometimes that occurs, and this kind of venue might be helpful for that. Not always, because sometimes they're asking for something very amorphous, like asylum or refugee, which is, as one federal court judge said, one of the most complex types of applications. In some respects, much more difficult than these express entry applications, which are predominantly paper-based. If you're lucky, you get maybe a 5 or 10-minute interview on the phone, usually about a concern, sort of like a mini PFL, a mini procedural fairness letter. And so front and center is documentary evidence, whereas complicated applications like asylum or spousal cases, in some cases, where there may be an interview, then there's written documentation like proof of a relationship, but then there also may be an interview, and then if the interview does not go well, then there's an appeal. So it can become extremely complex, because then there's an interplay between what documents were presented and further whether the responses during an interview were contradictory, and then leading the officer to think, well, what do I trust now? Because the oral responses do not cohere with what was presented in writing, or things of that nature, where the candidate did not know some key factor about his spouse that he reasonably should have, based on the material or documents that were filed. So these types of applications get extremely complicated in some situations when they get refused, and that's why immigration lawyers exist in Canada and the United States as well, based on the complexities of these kinds of laws. The other aspect of this, people sometimes go for, because they have a very particular issue, namely admissibility. They're thinking about filing something, but they have a drunk driving or DUI offense, and they want to know the impact of that. And in some cases, we have to get more information, because the law had changed during, I believe, the end of 2018 about the implications of this for certain categories of Canadian visa holders and things of that nature. So that means we want to on the one hand, when I hold these webinars, I want to sort of clear up what people see on the internet, such as rumored programs like amnesties and things of that nature. And also, on the other hand, we want to say that we want to be approachable as a law firm in some respects, to give at least basic guidance and basic direction, because we want to ensure people get some appropriate foundation before they act. In some cases, if they lack funds, then they may be forced to make an application without any advice. So if this can help in any way to buttress whatever research they may have done on the internet, then I hope that's of some utility as well for this. So those are sort of the types of things we encounter, not just during the webinar, but also when we come across like emails and calls and things of that nature for this. So the climate that we're seeing now, as I indicated earlier, is the refusal increasingly of temporary applications. And from the vantage point that I see here is that because the amount of numbers are so high, that we do see a lot of refusals. And this has unfortunately had a profound effect on the federal court, because I believe at a webinar today, a judge said that I think 25% of the federal court cases are what are called mandamus cases, which means cases that are taken to federal court because of delay. They're asking the federal court to order the immigration department to make a decision. In other words, there's simply just delays in the system. And another significant component are temporary resident refusals related to students, so study permit refusals. The amount are so profoundly high that there's a streamlined program where you can file a judicial review application in a more summary, straightforward fashion with less evidence and less documentary protocols. Because the idea is that in some senses, the reasons for the study permit refusal are sort of straightforward. And you don't need the formality of an affidavit, but rather simply have like a 250-word statement. And I believe, if I remember the protocol, the opposing lawyer, the government lawyer, has to get the notes as part of their response. And then this does not have to go through the entire process, because now in the worst case, we're being told that if you have to go through an entire federal court application for a judicial review, it might take 2 years. By contrast, in these streamlined programs, you could get a positive outcome maybe in like 30 or 60 days, because you're not going through the multiple steps, which are typically spread out over 30-day periods, like, opposing, applicant's lawyer files something, 30 days later, the government lawyer files something, 10 days later, the applicant's lawyer makes a reply, then we wait. So now, but even despite that, the court filings are still high because of the vast fluctuating changes with the immigration system in general over the past 2 or 3 years dealing with this. The election will be announced, I believe, Sunday for the end of April. So I'm hoping there will be some specificity to help those candidates who were the kind of victim of bad timing. The ones who graduated a couple of years ago and don't have jobs in the right sector, because they are economically established here for the most part, or they could prove that by their tax return. So in my opinion, there should be, since they have spent perhaps 4 or 5 years of their life here, and they could prove that they're working in a job, then they should have a viable pathway for this. I mean, obviously, we have to look at the interests of the country as a whole. And this is where governments have to make some hard decisions, and you can't please everybody, essentially, right? So I do see a kind of follow-up question here, which relates to the quotas, right? So will the refusals decrease? So the fiscal year is usually like April, so that's coming up. So then they should be calculating things during April. So then the reset of the sort of allocation of visas should be at that time. So I did come across, or maybe one of the lawyers maybe told me in our office that they had a spousal case that was a little bit old, and the email response from the Canadian Immigration Department was effectively acknowledging that at this time they're not going to issue the permanent residency, but implying that they want to wait a little bit before they make a decision. But they said it in a very concise, pithy way. But that was the message that they were conveying. So, with some hope, we're anticipating less refusals, because in a sense it's wreaking havoc with the federal court, because they don't just do immigration. I mean, they do intellectual property and merchant shipping, maritime law, and patent law and all the other stuff. So it's causing a huge drain on all the other types of cases that the federal court has to confront as well. So in the hope is that there will be, I think this in a sense is the reflection of the issues from the United States as well, where people, both US citizens and people who are underground, are looking for some kind of recourse. And the other interesting thing is, because there are now profound delays with the US immigration system, we see some creative solutions being pitched by Americans. For example, they get married to somebody in India or Bangladesh, and the process of getting a green card could take 18 months, from what I'm told. So they were thinking, well, as an American citizen, I can visit Canada, and then I want to have my Indian or Bangladesh wife visit Canada, then I can be with my wife while she's awaiting her US green card. So we're seeing some of that now, especially with like a young couple who first time married. They want to get on with their life. So Canada is sort of has to bear the brunt and of being geographically next door to the United States, which in turn it's having its own complex immigration issues, causing delays, leading to these kind of creative solutions which affect the Canadian immigration system, namely filing a Canadian application as a kind of stopgap for another purpose, named the United States green card, for example. So we're seeing a lot of this, right? So in those situations, again, where Canada is kind of, we have to deal with this as best as possible. So we always see somebody, oh yes, when somebody says in the chat, thanks for the good work, testimonial, then we always want to say, oh yes, please make every lawyer loves seeing somebody who's offering to make a testimonial. I can try to maybe send something in the chat about that. But so if you or somebody you're interested in is encountering an immigration issue, or maybe contemplating an immigration course of action, people always, it's not like, say, 20 years ago, where the information was kind of restricted. I mean, these things like what are called the immigration manuals, now they're all published online. I mean, now they're not all in one place, but with a certain intuition, and perhaps arguably with a legal background, maybe not a Canadian one, then you could, if you have a non-complicated case that's very straightforward, try to take a stab at filing something yourself, like a visitor visa application. The only concern I would have about this is that, because of the phenomenon of artificial intelligence being employed, then this has led to the wrongful refusal of these temporary applications because of the use of what is internally in the immigration department. Their internal lingo is called Chinook, which is an artificial intelligence system that is meant to streamline the decision making by the officer. And from what we tell, when this type of case has been litigated, what happens is this Chinook system summarizes the data of a visitor visa or study permit or work permit, and then the officer can look at the aggregated data for this. The concern is that the refusals get probably the refusals become more increased because the system, at least in its early iterations from 2021, it seems to have flagged anything that was slightly unusual, like a refusal from many years ago, which should not really be that prejudicial, because if a refusal took place more than, let's say, 2 years ago, then your circumstances would have been changed, presumably. And that's why you would have filed for a new visitor visa. But now anything that's slightly unusual is getting flagged for refusal. It's making the decision-making faster, but the concern for self-filing people is that if you don't have everything on the assumption that it will be refused, in other words, if you're not what's called setting it up in terms of supporting documents for federal court, then the Chinook system might miss something, and then you get a wrongful refusal, and then that one refusal in your record makes it very difficult to get a successful application in the future, which kind of forces you to go to federal court to challenge a wrongful refusal. So that's the phenomenon of some concern if you're self-filing. There's a question about Chinook and why they named it Chinook. And in my sort of slightly jaded perspective, they wanted to name it something like an innocuous weather pattern, because a Chinook is sort of like that pleasant, warm front that happens, I think, in Alberta, where all of a sudden all the snow melts rapidly and it's really nice and warm for 10 minutes. So they want to give you a warm and fuzzy feeling about something, which actually could be very insidious and could in some respects compromise the rule of law. So maybe it's this sort of euphemistic changes. Now, if there's some other government has some hideous program that does something awful called the Lavender Protocol or the Hannibal Directive, I don't know, there's something. So governments, I don't know if you're well read about George Orwell. There's a sort of aspect of doublespeak and things of that nature, which governments have to do to placate their populace, especially democratically elected governments. So anyways, that's sort of borderline editorializing a bit, but we're coming close to the conclusion of this. I want to make sure if there's any questions, then there's still time. On the other hand, if there isn't any questions, then I'll terminate. But in the meantime, I do see a question here. So the concept of H and C, humanitarian and compassionate. So this is a kind of a broad question. I can try to tackle this with that combination of trying to be giving the overall picture. So the kind of reason for H and C, or humanitarian and compassionate, is that the law sometimes has rather rough around the edge implications for people, and when that law has an unduly harsh impact, or maybe there's the absence of a law which is having an undue or harsh impact, then the idea is to temper the circumstances which are harsh and undue with a humanitarian, compassionate application. So there has to be some system embedded in the Immigration Refugee Protection Act to deal with that potential hard situation. So that's sort of the overall picture. But if I sort of narrow down to what are some concrete examples, then we look at things which are not always, but the sort of golden combination of success is something that is a circumstance beyond your control, which compelled you to be inside of Canada, because most of these agencies are inside of Canada applications. So you're inside of Canada, maybe your status has lapsed and you could not go back to your home country. Or maybe you have a child that's a dependent on you in Canada. Maybe they have a certain health condition that cannot be treated in your home country, and they're getting good treatment here, and the treatment is stabilizing the child's condition. But you don't have a pathway for permanent residency, such as spousal/family class or express entries, subcategories of Canada experience class, etc. Or similarly, maybe you're one of these increasing amount of people that we're seeing, which you did study in Canada. You had your 3 or 4, depending on when you studied, you had maybe a 4-year work permit, which they did give out during COVID. And now you've built your life here, and you have a successful basis for economic establishment because you've maintained employment, and you have an express entry profile, but you're not getting the points. So that's where some of my colleagues and I might want to explore this in more detail to see if there might be something viable in that situation. It's not automatic. Like I said earlier, we look for, and officers as well, they're looking for a really unique situation that almost certainly, or at least a 51% chance, would cause some extreme hardship to you or a dependent if you had to leave Canada. I mean, that's sort of a medium threshold. When I say 51% chance, that's synonymous with balance of probabilities under the legal criteria. So these H&C applications are, the phrase that comes to mind is kind of striking a balance between the kitchen sink approach, which is you try to look at every possible aspect of the person's life in Canada. But at the same time, you have to temper what the arguments are and what facts you're presenting, because the immigration officer only has a limited attention span. So from a practical point of view, when we do humanitarian compassionate applications, we end up writing like a 15-page letter because the client gives us a ream or 250 pages of evidence, and officers, we have to guide the officer saying, this is the H&C criteria, here are the relevant facts, and we have to highlight those facts very clearly to the benefit of the officer, showing hardship to the applicant and or their dependent children. So because it's, in a sense, it's kind of powerful. An H&C application does not require a sponsor, does not require a job in a particular way, but does require some form of economic establishment. And that's defined in some older cases as simply not being a burden on the states or on the government. In other words, not taking social assistance. That's sort of the fundamental aspect of economic establishment, which implies employability. But again, not always, because it's a very broad category. If you're an H&C applicant and you're applying in your late 60s or early 70s, then the expectation of economic establishment may not be that you have employment, but rather it might be that you have a life or death situation in your home country. And then they may temper the requirement for economic establishment with less rigidity in that scenario. So it's a very amorphous kind of concept in many, many situations. So I hope that gave a flavor of how H&Cs could be configured successfully. If not, I mean, we're a little bit over. If there's like a sort of pithy follow-up question, I can try to answer it. I can just look at the screen and see if any text materializes. But On the other hand, since this is the duration of the webinar, and I hope I've answered your questions, and with that, I'll leave you to enjoy the rest of your evening and have a good one. Thanks again. Bye-bye.